Am I on? Good. All right, we'll reconvene. My apologies for not reconvening when I said I would. I'm sure there'll be more than this, right?
Do you have the other ones for 3?
You mean these? That's all I have.
Way more than that.
All right. I know you're having a great time discussing things, but it's time to take your seats and we're going to get started. Well, there's leadership. Shh. Always works. Interesting. Thank you all. We're back. We have a fairly hefty agenda for the rest of the day. I think we do, out of just common courtesy, need to take a lunch break. At some point, we'll probably take an afternoon brief break. We'll see where we are. As Mr. Howard or someone else may say, we have a series of presentations that will go for 2.5 to 3 hours of folks, and then we have comment cards. So it's going to be a very, very full day. I think I'm going to, should we pick a time to break for lunch? Is 1 o'clock too late? Because then we can get 2 hours in. And then we'll take I think I'm going to say, normally I'd say a half-hour break, but I think I'm going to say 45 minutes because there are just so many good places. I know it's raining. There are places in the, there's this cafeteria, of course, which is quite good, but there's places in Union Station. There's Felipe's for anyone who's from not around here. You may want to go over there. There's Olvera Street, where I can relive my childhood. That's where I'm going to be, at the taquito place. And it's just a personal thing. So we will take about a 45-minute break at 1 o'clock. Any objections from anybody? If you have blood sugar issues or that doesn't, I got protein bars and the cafeteria is right out there. So with that, Mr. Howard.
Amel Wadwani from the Office of Chief Counsel will be presenting this item, and she'll introduce her colleagues.
Great. And Amel, are you going to talk about the schedule, or do you want me to actually go through that so people know the order, or the people who are speaking on it know their order?
I can go through it if you want.
Either one. Up to you.
I'll mention it at the end.
Okay.
Good morning. This is Amel Wadwani, Senior Staff Counsel with the State Water Board. I am here with Phil Wiles, Assistant Chief Counsel, Greg Gearhart, who's the Director of the Office of Information Management and Analysis, and Tom Mumley, Assistant Executive Officer at the San Francisco Water Board. The purpose of this workshop is to take comment on a draft order issued by the State Water Board last month on November 21st. The draft order addresses significant issues raised in 37 petitions contesting a municipal stormwater MPDS permit adopted by the Los Angeles Water Board on November 8th, 2012. We are taking oral comment on the draft order today, and we have set a written public comment deadline for 12 noon on January 21st, so next month. As Chair Marcus mentioned, we have a series of panels. We expect that to take about 3.5 hours of time, and then we will move on to individual speakers after that. Before we go on to the panel presentations, I'm going to very briefly summarize the process leading to the draft order and the future steps to prepare a final order. As participants in this process are aware, in addition to the specific issues in the petitions, the State Water Board views the proceedings on the Los Angeles MS4 order as an appropriate avenue for addressing broader questions regarding receiving water limitations in municipal stormwater permits statewide. Prior to the petition proceedings, the State Water Board held a workshop in November 2012 to consider several options for addressing compliance with receiving water limitations. The State Water Board thereafter received the petitions on the LA MS4 order and indicated in August of 2013 that it would fold its consideration of the receiving water limitations in municipal stormwater permits into its review of the Los Angeles MS4 order. The State Water Board accordingly sought 2 sets of responses to the petitions. First, the State Water Board sought responses related to whether the Watershed Management Program and Enhanced Watershed Management Programs in the Los Angeles MS4 order constituted appropriate alternative compliance paths for receiving water limitations compliance. Second, the State Water Board sought responses addressing all other issues in the petitions, including the appropriateness of numeric TMDL limitations, joint liability, monitoring requirements, and many other issues. The State Water Board then reviewed both sets of those responses, as well as the comments received at the workshop. The draft order that is the subject of today's workshop addresses both the receiving water limitations questions and all other significant issues in the petitions. While the draft order directs a number of revisions to the findings and provisions of the Los Angeles MS4 order, it does not revise the basic structure and approach of the Los Angeles MS4 order. This approach includes the requirements to comply with receiving water limitations and numeric WQLs and other TMDL limitations, as well as the option of the BMP-focused watershed management programs and enhanced watershed management programs to meet those limitations over time. The draft order finds that the watershed management and enhanced watershed management programs alternatives to the order, with a number of revisions to add further rigor, accountability, and transparency to those programs, with those revisions that those constitute an appropriate alternative for achieving compliance with receiving water limitations and TMDL-based requirements. In terms of setting statewide precedent, the draft order directs regional water boards to continue to require compliance with receiving water limitations in the MS4 permits that they issue. At the same time, the draft order acknowledges that MS4s may not be able to achieve all receiving water limitations in the near term, and therefore finds it appropriate for municipal stormwater permits to incorporate a compliance alternative that allows permittees additional time to meet receiving water limitations, similar to the Los Angeles MS4 order's approach. But the order recognizes that regional differences may dictate the use of different alternative compliance approaches, and rather than confining regional boards to one particular choice of alternative, articulates several principles to guide the drafting of such alternative compliance paths. A more thorough summary of the draft order's findings and conclusions are laid out on pages 72 through 76 of the order, so I'm not going to provide more detail here. We recognize that the Los Angeles MS4 order and the petitions involve complex, challenging legal, technical, and policy issues that require extensive commitment of time and resources to address. The order before the board today is a draft, and the purpose of this workshop is to hear from parties and interested persons who are close to these issues. The State Water Board will hear comments today, but will take no action on the petitions today. Rather, the comments that we receive today and the comments that we receive through the written submissions that are due January 21st will be considered carefully in drafting the final order. Adoption of that final order will be scheduled for a future meeting date. We will proceed to the panel presentations first, and we are beginning with the Los Angeles Water Board, followed by County of Los Angeles and Los Angeles County Flood Control District, Natural Resources Defense Council, Los Angeles Waterkeeper, and Heal the Bay. We have 19 petitioner permittees being represented on a panel. After that, I won't read all of them. This particular schedule went out over the LIRIS list, so I think most of the participants here have it. We have 2 more panels by permittee petitioners after that, actually 3 more, sorry. Then the Gateway Water Management Authority, Richard Watson Associates, County of Orange, County of San Diego, Riverside Flood Control and Water Conservation District will speak after that. CASPA and SEEB have presentations following, and then we get to the individual speakers. So I think at this point we're ready for the Los Angeles Water Board to.
All right, and they also have closing comments.
And they will have closing comments.
Just a reminder, as they come up, that there are specific time limits here, and it may be obvious. We wanted to come down here in response to the request that we have a hearing down here to make it easier for many of you to speak with us without having to come up to Sacramento. have some pretty hefty time allotments here, and I just would advise that sometimes less is more. Take your time. I'm not going to take it away because it's been given, but think of it as an opportunity in a workshop for us to hear the key points that we should be bearing in mind as we look at the draft order, as we read your comments, which undoubtedly will be quite long in some cases, but if you can distill the most important points for us to bear in mind as we approach this, that's going to be the most effective use of this time. Understanding the constraints within which we operate is most helpful. If you come up and tell us that you hate the Clean Water Act, that's not really going to be all that helpful to us, Reporter Cologne. If you tell us that we can rewrite it and do whatever, that's also not helpful. So help us be the decision makers in this, in the context in which we work, and we're really eager to get your thoughts and illumination as a preview of what we probably will get in writing. There's something very valuable about actually talking to humans about things, and so I'm delighted we were able to come down here, and I think we're all sitting here with very open minds to hear what you have to say. So I look forward to it. And now, Mr. Stringer, Chair of the Board. And Renee is just second chair? Okay.
Good morning. Chair Marcus, fellow board members, staff, thank you very much for coming down here. It actually made it possible for me to address you. I don't think I would have been able to make it up to Sacramento. I'm joined by the Regional Board's extraordinary and incredibly committed and hardworking staff, and my fellow board member, Fran Diamond, and Maria Moranian was here, but she had to leave. She was actually the chair when we adopted this permit, and so it was under leadership. I'm going to do something I don't normally do, but I want to be succinct, and I want to make sure that I get everything conveyed to you that I want to convey, because it's complicated. I'm going to read a statement, which I don't normally do. I will say it's nice to be talking about stormwater management when we actually have stormwater to manage. Some of us thought we wouldn't get to this place.
Yeah.
So it seems appropriate.
Yeah, definitely worth mentioning.
And just by way of beginning, I'm here to say that we wholeheartedly, support the order, and we very much appreciate the incredibly thoughtful approach that the board has taken to the proposed order. In 2011 and 2012, the Regional Board placed development of an effective MS4 permit for Los Angeles County and the cities within the county as our highest priority. As we embarked on this process, we considered the latest science and policy, as well as the lessons learned from regulation under the prior permit. Under the leadership of board member Maria Moranian, who was board chair at the time, we also committed to extensive outreach, both at the staff and at the board level. Over the course of 2 years, we held 9 public workshops, released several working proposals for review and comment, participated in hundreds of discussions and meetings with stakeholders, and held 3 days of hearings. It's fitting that we're here today because we held many of those hearings and workshops in this room, and we actually adopted the permit here in this room. In developing the permit, there was an unprecedented level of collaboration among the permittees and other stakeholders. While consensus was not achieved on all provisions of the permit, we actively listened to stakeholder concerns. There were significant areas of agreement that resulted in the board's outreach, which is reflected in the permit. As Renee Purdy will discuss momentarily, this level of collaboration continues to this day as we move on to permit implementation. The 2012 permit reflects lessons learned by the Regional Board over 2 decades of regulating MS4 discharges through NPDES permits. It also reflects consideration of the physical and regulatory factors present in LA County, including the need to implement a multitude of watershed-based TMDLs. These factors present the board with an opportunity to facilitate, through the permit and on a watershed basis, new integrated solutions to addressing both water quality and water supply issues. In addition, best management practices for stormwater have greatly improved in recent years. The LA County MS4 permittees have gained experience in successfully implementing structural BMPs tailored to achieve TMDLs, such as full capture systems for trash, low-flow diversions, urban runoff recycling facilities, regional multi-benefit projects, and site and neighborhood level, low-impact development. Against this backdrop, we issued a permit that focuses on achieving specific water quality outcomes. The permit also champions progressive policy, such as treating stormwater as a resource rather than a problem. I will briefly summarize a few main points as to why the board adopted this particular permit, as you will see in the following slide. First, one of the most significant additions to the permit is the incorporation of water quality-based requirements to implement 33 TMDLs, as required by the Clean Water Act. As you know, over the last 15 years, the Regional Board and MS4 permittees have spent valuable time and resources developing TMDL implementation plans. The permittees have already been collaborating on a watershed scale to begin to successfully implement those plans. Thanks to the TMDLs, a framework for watershed-based and water quality-driven permitting is in place. The permit builds on this work by providing linkages between the water quality-based requirements, namely the receiving water limitations and TMDL provisions, and the historical programmatic elements of the permit. These linkages are established through Watershed Management Program and Enhanced Watershed Management Program alternatives. These alternatives are designed to incentivize watershed-based solutions, facilitate collaboration, support prioritization of actions, and ultimately ensure improved water quality. The Watershed Management Program alternatives also foster early planning and coordination to facilitate success in meeting the water quality-based requirements. In doing so, the board recognizes that a reasonable amount of time is needed to develop and implement robust programs to achieve water quality standards. Second, as we previously indicated in our written submissions, the prior MS4 permits did not result in the water quality outcomes that we had hoped for, namely the achievement of water quality standards. The Regional Board crafted the alternative watershed management programs to provide a more proactive, rigorous approach to achieving receiving water limitations. The board concluded that this, along with greater accountability through predetermined deadlines and monitoring of both receiving waters and MS4 outfalls, will more successfully lead to achievement of water quality standards, which is, of course, the cornerstone of the permit. Third, the permit reflects a paradigm shift from treating stormwater as an asset rather than a liability. For large urban areas, such as LA County, the largely untapped stormwater resource is one of the keys to the sustainability of local water supplies. The integration across local agencies that deal with water quality and water supply will take time. The LA County MS4 permit provides such time to build the partnerships, plans, and projects that both address stormwater quality and promote sustainable water supplies for Southern California. In closing, the Regional Board unanimously supported the new direction based on the water quality challenges in the LA region and the permittees' collaboration and commitment to addressing these issues. The permit provides flexibility and time to support this collaboration, leading to efficient and cost-effective solutions and significant water quality improvements. As you'll hear from Renee, in the 2 years since its adoption, we continue to see significant and proactive efforts on the part of the majority of permittees. Thank you.
Thank you.
Thank you. Good morning, Chair Marcus, members of the board. Renee Purdy, I'm Chief of the Regional Programs Section at the Regional Board, and I just want to thank you also for coming down here today so that all of our permittees and stakeholders can be here and be present for this very important event. So as our Chair Stringer said, we have been actively working on permit implementation since very shortly after the board adopted the permit. And I want to talk to you a little bit about the status of that right now. The Regional Board first, in the first 6 months after the permit was adopted, held a series of informational sessions and many one-on-one meetings with permittees to help them make the decision about whether a watershed management program or enhanced program would be the right option for them, and to also facilitate the development or the formation of watershed-based groups. In June 2013, 6 months after the permit term, or into the permit term, the Regional Board received 31 notifications from permittees indicating their intent to either collaboratively or individually develop a watershed management program or enhanced watershed management program. That included all permittees but one that decided to embark on one of these programs. We reviewed each of these notification of intent packages for completeness and accuracy and responded to each one in writing. In several cases, we did require revisions to the notification packages or supplemental supporting information. During that review, 2 cities that planned to initially do an individual program chose to join a group at that point. Once permittees made their decision to either develop a watershed management program or an enhanced program, in July 2013, the Regional Board formed a technical advisory committee as called for in our permit to help the permittees as they developed these programs. The TAC met 8 times from the summer of 2013 to the summer of 2014, and the main focus of those meetings was on the Regional Board's expectations for the various elements of the watershed management programs and enhanced programs. And in particular, we spent a significant amount of time on the reasonable assurance analysis, which I'm sure you've all read about in our permit, and in particular, the various modeling components of that reasonable assurance analysis. In the spring of 2014, the watershed groups that had formed held stakeholder meetings to solicit input on their draft watershed management programs and enhanced program work plans. Then in June of this year, I would ask if we could perhaps cut into some of our 10 minutes at the end so I can conclude my comments. Is that fine?
No, it's helpful to lay the foundation again for the people who are listening over the web in particular.
Okay, fantastic. Thank you. I may have about 2 minutes more, and that's it. So in June of this year, we received 17 watershed management programs, 7 collaborative programs, and 10 individual watershed management programs. We also received 12 enhanced watershed management program work plans and 30 monitoring programs. Needless to say, there were a lot of documents that came in June of this year. These were all posted to our website and publicly noticed, and stakeholders were invited to submit written comments on those draft plans and work plans. In October 2014, just 2 months ago now, hard to believe, we held a board workshop on the 17 draft watershed management programs that we had received to provide the opportunity for our board to hear from permittees and other stakeholders regarding the draft programs. By the end of October, we had reviewed the 17 draft programs and provided written comments on those 17 draft programs. We found 7 of the individual watershed management programs to be deficient, and we notified permittees at that point that they were now subject to the baseline requirements of the permit, including compliance with water quality-based effluent limitations pursuant to our Part 6E, which is our TMDL provisions, and compliance with the receiving water limitations pursuant to Part 5A, which are the receiving water limitation provisions. The other permittees are currently working on responding to our comments and making the necessary revisions to their draft watershed management programs. So at this point, I want to just turn to this slide. We have over 90% of our permittees who are pursuing either a watershed management program or an enhanced program, which is 78 of our 86 permittees. 46 of the permittees are participating in enhanced programs, which are the solidly shaded areas on the map. 43 are participating in our standard watershed management programs, which have, it's a little bit difficult to see, but have some stippling on them. Oh. The gray hatched areas are participating in the individual watershed management programs, and the solid gray areas are those areas that are not participating in any type of watershed management program. And before you wonder about my math in terms of the 46 and the 43, some are participating in both types of programs. Now we're in the process of reviewing the 30 monitoring programs that we received, and we've completed approximately 1/3 of our reviews of those programs. So based on our experience reviewing these various watershed management program documents, we are going to be submitting some written comments suggesting some minor revisions to some of the new deadlines in the proposed draft order. Lastly, I did want to note before I close that during this focused planning period that we've been having, permittees have continued and have initiated a number of implementation activities as well. The regional boards worked with several permittees to develop time schedule orders where there have been final TMDL compliance deadlines that have passed and permittees needed additional time to come into compliance. Permittees have continued to implement their core stormwater management programs that they've been historically implementing. A number of permittees have adopted low-impact development ordinances and green streets policies for their cities. And additionally, the enhanced program permittees have been implementing what we call their early action best management practices, which are structural best management practices that they were required to implement given the longer planning period allowed for the enhanced programs. Finally, the monitoring, the TMDL monitoring, mass emission station monitoring, and bioassessment monitoring continues unabated. So in summary, permit implementation is proceeding as we anticipated it would. And as our chair, Chair Stringer, said, we are continuing to see a high level of collaboration and commitment among permittees, and we will continue to be working with them as they begin to implement these watershed-based programs. Thank you so much.
Thank you very much. Helpful. Next, we have the County of Los Angeles and the LA County Flood Control District, and I don't have a name for who's speaking on their behalf.
Good morning. My name is Teresa Villegas. Good morning, Chair and Board. I am here representing LA County Supervisor Hilda Solis, and with me is also my colleague, Susan Nisman, representing LA County Supervisor Sheila Kuehl. I appreciate the opportunity to speak to you and address you today. We'd like to thank the staff for working in this effort in developing the order. We are here today on behalf of the LA County and the Flood Control District to express our support for the MS4 permit and for the order. And we just want to recognize the vision of the LA Regional Water Quality Control Board in establishing this permit and doing the groundbreaking work that they've done over the last 2 years. The staff has done a tremendous job. We feel that it's been a collaborative approach and it's very innovative, and it's going to get hopefully the results that we anticipate in the near future. We, to date, have, as you previously heard, 19 watershed management plans and enhanced watershed management plans, and we look forward to the implementation of those. My comments are just going to be brief, but I did want to let you know that we are in strong support of this. Thank you.
Thank you.
Good morning, Chair Marcus and members of the board. My name is Susan Nisman, and I'm here representing Los Angeles County Supervisor Sheila Kuehl. As the draft order states, the permit is truly groundbreaking because for the first time, stormwater is viewed as a resource and not a liability. This is an important regulatory paradigm shift as the state and our region continue to experience one of the worst droughts on record. And even if we're not experiencing the worst drought on record at this moment. As a result of the MS4 permit, the county and over 40 partners in the enhanced watershed management groups are working together to find more ways to capture and utilize stormwater. In our view, the State Water Board's draft order, if approved, will allow the LA region to continue to move forward towards a sustainable water system while promoting healthy watersheds. The flood control district's responsibilities include both flood control and water conservation. As a result, the district operates water conservation programs and recognizes the benefits of facilitating recreational uses and environmental protection through these programs as well. Under the new permit, we look forward to expanding this program with our cities and other agencies as our partners. We recognize that the permit is very ambitious and the cost of implementation is very high. 2 years into implementation, the county and the flood control district have already spent tens of millions on the requirements, including extensive watershed planning. This amount will continue to increase over the coming years. However, we also recognize that this challenge can be met if all levels of government continue to work together to secure additional funds for clean water, and as such, the county will continue working with other permittees, the Los Angeles Regional Board, the State Board, and to find additional funding sources, including future grant opportunities from the recently passed Water Bond Initiative. This is truly an exciting time to be implementing innovative stormwater improvement projects throughout the varied region. Thank you very much for your time and tremendous work on this important permit. County staff is available if you have any further questions. Thank you very much.
Very much. Appreciate you all joining us. Mr. Lawford? Not just to tell you how gratuitously how great you are. At some point, we should remind everybody, we could do it now or after the close, what the ex parte rules on this particular kind of thing is. I think I know it, but I'd rather have you explain it to everybody because there's some confusion. Do you mind doing that briefly? I'm sorry, I meant to do that at the outset.
No problem. I think to the extent there is any confusion, it stems from the fact that actually, while I think this group of petitions was pending, there was a piece of legislation passed that modified some of the ex parte rules with respect to the water boards and what are known as general orders. And some people have assumed, because of the large panoply of permittees under this permit, that it is a general order. In fact, ex parte prohibitions apply to communications with the board members concerning issues in this particular proceeding. And so this is the board members' forum for receiving comments on the petitions and on the draft order. And we will be providing, as Ms. Wadwani indicated, subsequent board meetings so that there is more than adequate opportunity for public comment. But that really is the only venue for it to the board members. And then, of course, the written comment period that we provided until January 21st.
Thank you very much. I just wanted to make sure I wasn't wrong in what I was telling people. So thank you. And next we have a panel with the NRDC, LA Waterkeeper, and Heal the Bay. Guess we don't have a place for you to sit as a panel, so you have to you've divvied up your time amongst yourselves.
Yeah, we appreciate it. We'll be coming up and down. So,
okay.
Thank you. Good morning, Chair Marcus and members of the board. My name is Steve Fleischle. I'm the Water Program Director at the Natural Resources Defense Council. We do have a slideshow. I'm here today representing NRDC along with Heal the Bay and Los Angeles Waterkeeper. Thank you for the opportunity to comment on the draft order, which addresses the fourth iteration of the Los Angeles MS4 permit. A few of the major points we'll be making today. As you all are aware, notwithstanding prior efforts, urban runoff remains the #1 source of water pollution in Southern California. And the failure to address this problem is not due to the language in the 2001 permit. Rather, it has been a failure in implementation, and it has been a failure in oversight. To attempt to solve this problem, the 2012 permit creates a process for watershed management plans and enhanced watershed management plans, which the draft order largely upholds for the LA MS4 permit, but also, as you've already heard, recommends the same on a statewide basis. We disagree with this approach both for Los Angeles and across the state. Most notably, in certain circumstances, the draft order excuses compliance with water quality standards through what are known as safe harbors. From the regional board, we often hear alternative compliance path. The draft order acknowledges that they are safe harbors in certain circumstances. We are opposed to safe harbors. These safe harbors are based on an adaptive management process in the draft order and the permit that suffers many of the same shortcomings as the iterative process did in 2001. Unfortunately, the draft order treats WIMPs and EWIMPs exactly the same, even though in practical terms they are not. The draft order similarly treats dry weather and wet weather in the same way, even though in practical terms they are not. The draft order also raises potential unfunded mandate issues that we are very concerned about. But there is a better way than what's being proposed here, and that is to embrace your enforcement authority and reject the safe harbors in the permit. I'd like to now ask Peter Schellenbarger from Heal the Bay to give some background on the magnitude of the problems that we face.
Thanks, Steve. Peter Schellenbarger here from Heal the Bay. I'm sure you're all aware of the serious water quality problems here in California. From 2006 to 2010, assessed rivers, streams, and lakes showing toxicity increased 170%. The map here denotes severely polluted water bodies in California, which is roughly 83% of assessed streams and rivers. And in addition, 96% of the total assessed lakes and reservoirs are impaired. Here in Los Angeles, nearly all water bodies are impaired. Over the last 8+ years, Los Angeles County bacteria TMDL numeric targets have been exceeded over 4,500 times. These exceedances surpass several TMDL compliance deadlines as noted in the figure here. And Los Angeles County's MS4 persistently contributes to violations of water quality standards and TMDL requirements. From 2003 to 2013, water quality standards were exceeded over 1,283 times at the county mass emission stations. Mass emission stations should be judging the health of Los Angeles major water bodies, and the water quality standard exceedances need to be addressed appropriately. On a continual basis, beneficial uses are impacted. I'm sure we're all aware. Rec 1, Rec 2, warm, wild, et cetera, et cetera. But really, the basis is humans and the ecosystems that rely on these waters are negatively impacted by stormwater pollution on a continual basis. California has the largest ocean economy in the United States. It accounts for over 375,000 jobs, $10 billion in wages, and $20 billion in goods and services on an annual basis. In 2000, NOAA found that an increase in water quality in Long Beach from a C to a B grade could create an $8.8 million in economic benefits. There is a clear nexus between water quality and economic productivity. In addition, poor water quality impacts human health. Regional public health costs associated with recreating in polluted waters is between $21 million and $51 million annually in LA and Orange County alone. Stormwater pollution is attributed to a large contributor to this. Steve will continue the presentation.
If there aren't enough seats, Phil points out you can use the seats at the table if you want.
That's great.
So
Thank you. Thank you. There'll just be one more switch with Liz. We wanted to make sure Heal the Bay had an opportunity to talk about the water quality impacts. It's very important, and I know you're all aware of those impacts. And while we might disagree with a lot of the things in the draft order, we don't actually disagree with everything, and I think it's important that you hear that as well. We agree that the receiving water limitation language should be maintained in the 2012 permit, and the draft order recognizes that. We also agree that TMDL should be incorporated into the permit. We agree that permittees should be incentivized to capture stormwater for reuse. There are huge opportunities to benefit from stormwater capture, particularly here in Southern California. A recent study by NRDC and the Pacific Institute found that even modest stormwater capture efforts in both Los Angeles and San Francisco could yield between 400,000 and 600,000 acre-feet of new water available for us. We also agree that multi-benefit-based watershed approach, BMPs, should be a priority. And we agree with the draft order that the iterative approach has been ineffective. But instead of solving that problem and resolving that problem, the 2012 permit takes a similar approach to the iterative approach, and it also rewards failure by creating these safe harbors in certain circumstances. These safe harbors are a major step backwards and retreat from more than 15 years of precedent, including by EPA, the regional board, the state board, and in legal filings by the Attorney General's office in both state and federal courts. The regional board has previously rejected safe harbors. In particular, in a filing in federal court on behalf of the regional board, the statement was made that the regional board did not include a safe harbor in the 2001 permit, and under California law could not have done so. The representation was not that they chose not to, they represented that they could not have done so. Similarly, prior statements from the regional board staff council, which at the time was Michael Loffer, and I must say, 15 years ago, I was the founding member of the Michael Loffer fan club when we all worked at the regional board.
We need someone to call the mayor and make it Michael Loffer Day.
Yeah, make a Loffer Day today. Those discharges are required to conform to the permit, but are subject to the underlying restrictions of the Porter Cologne Act. Namely, the discharges from the MS4 may not violate the water quality objectives in water quality control plans or contribute to a condition of nuisance. The state board also, under both the Davis and Schwarzenegger administrations, has rejected safe harbors. First, in Water Quality Order 99-05, which set the basis for the 2001 permit, and then again in 2009 when the Santa Monica Bay Dry Weather TMDL was on appeal to the State Water Board. And these safe harbors were rejected for good reason. Enforcement can drive success. And one of the best examples of that is the City of Los Angeles sewage spill case. In 1999, the Los Angeles Waterkeeper, and then later EPA and the regional board, sued the City of Los Angeles for violations of its POTW permit for sewage spills. They were having 2 sewage spills a day within the City of Los Angeles. The city was found to have violated the Clean Water Act 3,600 times, and then entered into a consent decree with the parties. Since then, the city has reduced sewage spills by 82% because of their activities under the consent decree. In fact, they recently had a party to celebrate closing the consent decree, and all of the parties were there, and they held hands and sang Kumbaya, basically, to say that they're all on the same page moving forward. Ironically, some of the stormwater projects that came out of the sewage case are many of the success stories you'll hear about today. In particular, the one in the upper right is the Jan Perry South LA Park. And the one on the bottom right is the Garvanza Stormwater Project, both of which I know the chair has visited and seen in person. And those came about because of a sewage enforcement case, not because of stormwater enforcement. Another good example is Kramer Metals, which is an industrial facility. On the left is the facility prior to enforcement by the Los Angeles Waterkeeper. On the right is the facility after compliance with the order in that case. They now capture the 5-year, 24-hour storm event, which is actually more than the municipal stormwater permit even contemplates in the EWIMPs. Now, a lot of the cities do like to complain about enforcement, but the fact is the permittees were in immediate non-compliance with water quality standards back in 2001. Many of them acknowledged that during the proceedings on the 2001 permit, and many others acknowledged it in the state court proceedings that challenged that 2001 permit. Yet to this day, stormwater remains the #1 cause of impairment in Southern California, and yet only 2 lawsuits have ever been filed against municipalities for violating stormwater rules. Instead of embracing a compliance approach, the draft order justifies safe harbors based on the WIMPs and EWIMPs and an adaptive management approach. But unlike is claimed in the draft order, neither of these approaches is ambitious, rigorous, or transparent, nor do they provide a well-defined, transparent, or finite path to compliance. The EWIMP process tries to promote stormwater capture, and we concede again that stormwater capture is a good thing. But the EWIMP approach fails to demonstrate that water quality standards will be achieved. The order even acknowledges, quote, "There is no definitive evidence in the record establishing that the stormwater retention approach will achieve final requirements." And yet the proposed revisions in the draft order don't change that finding. Worse yet, the WIMPs, the watershed management programs, in the permit also include a safe harbor, but they don't even require or make mention of stormwater capture as a goal. There is no multi-benefit approach in the WIMPs. All the good stuff is in the EWIMPs, and yet WIMPs are treated the same as the EWIMPs. For that reason, the claim that we are incentivizing stormwater capture through these safe harbors and through the WIMP process is arbitrary, capricious, and abuse of discretion. So if you look up at that slide, the EWIMP adds in the multi-benefit regional projects that, where feasible, retain all non-stormer and stormwater with the 85th percentile storm. None of that language is in the WIMP process at all. Another basis for the safe harbor is the adaptive management approach in the permit. But the adaptive management approach suffers many of the same shortcomings as the failed iterative approach. We all acknowledge that the iterative approach failed. In particular, the draft order says the iterative approach has been underutilized and ineffective to date in bringing MS4 discharges into compliance with water quality standards. And partly why was that? It's because the iterative approach said either the regional board or the discharges had to identify that there was an exceedance of water quality standards or a violation, and no one was ever willing to do that. The draft order says that we cannot accept a process that leads to a continuous loop of iterative WIMPs and EWIMP implementation without ultimate achievement of receiving water limitations. We agree. This is a table that we put together comparing the iterative approach from 2001 with the adaptive management process from 2012. The green indicates things that we consider to be good. The red indicates things that we consider to be bad or not lead to compliance or that they promote delay. And the yellow are things that we are cautious about. Where the colors are the same within the two columns, we view both the iterative process and the adaptive management process as suffering from the same problems. As you can see, they're very similar in many circumstances. The second row down, water quality standards compliance deadlines, the iterative process does better because there is no safe harbor. It's immediate compliance. The adaptive process gets red there. The one place where the adaptive process is slightly better is in the public comment opportunity that it provides. So if you go farther down, there's no public comment period for comment on the iterative approach, but there is a public comment period on the adaptive management approach. But that does not solve the problems. Expecting the public to come up and solve the problems of the WIMP and the EWIMP, that will not resolve the problems that the EWIMPs and WIMPs suffer. And in many cases, in some cases, excuse me, the 2012 permit creates a potentially endless loop where cities need to resubmit WIMPs and EWIMPs every 6 years, simply leading to more process and more delay and non-compliance with water quality standards. I'd like to now turn it over to Liz Crossan with LA Waterkeeper to discuss some other flawed justifications in the draft order. Thank you.
Good morning. Welcome to Los Angeles. I'm Liz Crossan with Los Angeles Waterkeeper. So I'm going to talk about a few issues related to the justifications provided for the permit as is in the proposed order. And not only is the process provided in the 2012 permit not a new approach when compared to 2001, but neither are the reasons to justify it and to justify the safe harbors. We simply cannot say that the concepts of the WIMPs or the EWIMPs are new, and thus they do not warrant additional delay in implementing water quality standards. The draft order and the regional board state that the regional watershed approach is a new paradigm. But these solutions, the ideas and the concepts are not new. They're not new to the regional or state boards, they're not new to the permittees, and they're certainly not new to the NGOs that have been urging the permittees to take a more comprehensive approach to stormwater for over a decade. For example, in legal memos back from 2001, you see Chief Counsel talking about regional solutions. We also have NRDC's comments from the 2001 permit, which talked about regional solutions. Looking back at the 2001 transcript, that also reveals the discussion of regional solutions as the way to deal with stormwater. Additionally, the watershed approach is not new. And our point here is not to say that these aren't the way to undermine this approach. We fully support this approach. Our point is that we have for over a decade, and that the fact that permittees are starting to move in this direction does not warrant additional delay, because these standards, the receiving water limitations, have been in place for over 13 years. We've seen the watershed approach in the 2010 Ventura permit. We've seen it implemented in other regions throughout the country, including Philadelphia and Seattle. And some of the permittees themselves have actually been implementing these projects throughout Los Angeles. These are a couple City of LA projects, one that does look at a small part of a watershed and treat it naturally before it reaches the LA River, and then a larger infiltration gallery project that City of LA implemented as well.
Can I just ask, I don't
Of course.
Is it okay to interrupt you?
Yeah.
I don't want to break up the flow. But isn't the issue not that it's new, but that it takes more time to do than a treatment option at the end of a storm drain, because it requires cooperation across jurisdictions or across silos? The theory is not that it's new, isn't it? The theory is just that to do it effectively takes more time.
Well, there's a couple things. There have been, the use of new information has been used, for example, as a reason that this particular approach is accepted from the anti-backsliding provisions of the Clean Water Act. So in that regard, new is an important concept to discuss. But you're right in the fact that it is about whether more time is warranted. We actually, and I'll get to this, we do have a proposal which we believe could afford more time to address the fact that some of these projects will be larger and will need implementation time and planning and interim deadlines. But we have proposed something that we believe also is consistent with the Clean Water Act and provides certainty for all of us. So again, stormwater capture is not something that is new to this particular permit. It's been implemented for a long time. And of course, we do support it. It's a fantastic approach to addressing stormwater, but it is not something that we think should just result in an indefinite amount of time for compliance. And I think it's also important when you talk about regional and multi-benefit, which Steve mentioned, is that this is only with regards to the EWIMPs. So the watershed management plans themselves do not even require consideration of things like regional solutions or multi-benefit or the water supply solutions that we all support and want to see happening here in Los Angeles. So in addition to the concerns about the safe harbors themselves, we just want to point out a couple of what we consider to be perhaps unintended consequences of what's written in the draft order. And the first one is with regards to non-stormwater discharges. They're treated similarly to stormwater discharges in that they appear to be subject to safe harbor provisions. And this is directly contrary to the language in the Clean Water Act, which prohibits the discharge of non-stormwater. And I can say in my review of the WIMPs and EWIMPs in practice, this is also true, that in the development of these plans, we are seeing the plans address both stormwater and non-stormwater, despite this clear prohibition. The second two considerations are unintended consequences as we've framed them. One is the potential implications relating to unfunded mandates. And while we don't support the arguments that have been made in the current ongoing litigation with regards to unfunded mandates, we do want to caution you to think about some of the broad language that's used with regards to your discretion in implementing these permits. And then lastly, of course, something that's a concern of ours is the potential de-designation by EPA for stormwater, for the stormwater program, should the board move forward with permits that include safe harbors. And the regional board itself, here in an amicus brief that was submitted in a federal court, states that they are also concerned if they included a safe harbor that they could be at risk of potential de-designation. So due to our concerns about, that we've presented today about the safe harbors and the justification for the safe harbors, we still urge the board to consider removing those safe harbor provisions, and here are a few of them. The first to apply to compliance with receiving water limitations where there are no TMDLs. So upon, this first one here, upon notification of a permittee's intent to develop a WIMP or EWIMP, a permittee is deemed in compliance with the receiving water limitations. And just as a reminder, these limitations have been in place for over 13 years. And this is before any actual implementation takes place. It can be years before actual implementation takes place in some of these locations. This is just the planning phase. And here you can see in the safe harbors, WIMPs and EWIMPs are lumped together. So there is no distinction here between permittees that choose to consider those regional multi-benefit projects that we all support and those that don't. And I think that's a really important point. The second one here is that so long as a permittee complies with the requirements and dates, and it's the dates that they've set in their own watershed management plan, as long as they comply with their own dates in their plan, and again, EWIMPs and WIMPs are lumped together, the permittee is deemed in compliance with the receiving water limitations that have been in place for over 13 years. And in my review of some of these plans, this date in some cases is as late as 2040. So we're talking about 40 years since they've been required to comply with receiving water limitations before they're committing to do that. And there are still mechanisms in the permit for further extensions. These two provisions, these two safe harbor provisions, address where there are TMDLs in place. This one is similar to the previous one related to just upon notification of a permittee's intent to engage in this process, they're deemed in compliance, again, with WIMPs or EWIMPs. And then the second one here is with regards to only EWIMPs, and that it actually deems a permittee to be in compliance if they're engaging in that EWIMP process to actually retain stormwater, even though the draft order itself states that there isn't sufficient evidence in the record to determine that this will actually meet final limits. So these are, just in short, the provisions that we believe legally need to be removed from the permit in order for it to move forward. But we do have this alternative approach, and I think that this is a really important, an important part of our proposal and our presentation here, is that we do support this regional approach and watershed approach, and we do want to see multi-benefit projects that include collaboration among water supply and water quality agencies. That is certainly a priority of ours. But we do believe that in order for this permit to be legal and to meet the water quality standards we're all charged to meet, that we need a permit that includes a rigorous scientific pollution prevention program, and that time for implementation could be provided for in enforcement orders such as TSOs and CDOs and cleanup and abatement orders. And compliance is based on implementation of that program that's actually been demonstrated through peer-reviewed modeling and approved modeling that actually demonstrates you will meet those numbers and within the life of the permit. And all of the monitoring would need to continue, but ultimate compliance, and this is the most important piece, is determined through monitoring itself. So these are the general principles, and we do believe that this approach provides a legal mechanism for moving forward without unjustifiably rewarding permittees for the shortcoming that's been exhibited in the last over 13 years. More specifically, where TMDLs have been adopted, we want to see a demonstration that the pollution control program that's been proposed, and it could be called an Enhanced Watershed Management Plan, will achieve compliance with whatever the applicable waste load allocations are within that 5-year term of the permit, and that the time is provided not in the permit itself, but in this enforcement mechanism. And where TMDLs have not been adopted, that they would do the same, but it would have to be demonstrated that they could meet those within the 5 years of the permit term. And so in the draft order, there's actually some language about why they don't think that this enforcement order approach would work. And I just want to quote from the draft order, which says that generally permits are best structured so that enforcement actions are employed when a discharger shows some shortcoming in achieving a realistic, even if ambitious, permit condition, and not under circumstances where even the most diligent or good faith effort has been made. But again, there is no appropriate reason now to restart the clock because permittees have shown those shortcomings over the last almost 15 years in their implementation of the 2001 LAMS4 permit. And this is exactly the right time to provide some guidance on measures to implement as the EWIMP does. but also to actually enforce long overdue water quality standards through a strong permit and enforcement orders, and to ensure that ultimate compliance is demonstrated in the water bodies that we are all charged to protect and restore. So we urge you to please consider this approach that we believe meets all of our goals for this permit while providing some certainty for all of us. And I would like to reserve the rest of our time for later in a rebuttal. Thank you.
Are we doing rebuttal?
We haven't designated rebuttals, but if you want to give them an opportunity to have some time at the end to do so, it's up to you.
All right, depends on how you define end, because I do want to also get to the public comments.
Sure. The only party that was actually given officially a time to speak again at the end was the regional board. And I think if you were going to allow some time for the environmental groups to take 5 minutes to do so, it would probably be after the individual speakers prior to the regional board.
Right, and my concern is that we have a whole host of speakers who may want to reserve time for rebuttal, but I don't want to encourage people to use all their time. So you see my conundrum here.
Right.
So here's what,
If I might, one of the reasons for the
you
rebuttal
may,
is...
because you have some time left. So.
Yes, yeah, thank you. We were one of the petitioners, and we would only want to rebut the other petitioners' comments. That's all we would seek to do in case they raise issues about our petition or responses to our petition. And since they're going after us, we think we have that right.
All right, well, let's figure it out, because again, this is a workshop.
Yes.
This isn't the hearing on the petitions, and so we're trying to get, again, you're trying to set our neural nets for how to read all of this and how to talk with staff and approach it. So I want to just, I'm not going to decide whether I'm going to let you or not. I'm just going to wait and see where we are at the end. Because
I respect that.
If we keep doing it, even though it would be within the regular amount of time, it might kind of go on forever. So
I respect that. I just want to make sure that if someone says something really egregious, we have an opportunity
anybody
to
calls
address
you
that.
names, you're like right there.
They can call me good names, though. That's okay.
Okay,
I'm
okay.
giving them fair notice.
So that's right.
Could I ask
Yeah.
a question?
Oh, yeah, you can ask, questions would be helpful.
A question, or I guess a request, if you don't have an answer today. I'm intrigued by your proposal, and I'm curious, do you have an example, either to provide right now or through your written comments, of a submittal from a regulated entity that demonstrates such compliance? What would such demonstration of future compliance look like? What would be the components, and has there been any examples provided?
In terms of what types of BMPs would achieve water quality standards? Is that the direct issue? Off the top of my head,
well, I'm sorry, your proposal is that there be demonstration
or the process.
Yes.
Yes, so the models
within
would
5
demonstrate,
years.
first the models would demonstrate, the calibrated models would demonstrate that water quality would be achieved, and then water quality sampling end of pipe or after the BMP would demonstrate that water quality standards are being achieved. Whereas in the draft order, I don't have the language right in front of me, there's sort of a loop of logic in there. It's somewhat Orwellian, where it says, even if water quality standards are not being demonstrated through monitoring results, you'll remain in compliance as long as you do the following things. And it's like, well, wait, when does it end? When do you actually say at the end of the day that water quality monitoring is tied to achievement of water quality standards?
So in your proposal that requires a demonstration of compliance, you are actually looking for water quality monitoring data to actually demonstrate compliance?
Yes. At the end of the term, yes.
Could you do that looking forward?
Well, the models would indicate
models,
up front that you expect it to achieve that.
So
Whereas the
it's
85th
modeling.
yes, so for the 85th percentile, for example, that's been put in the permit, and yet the evidence in the record doesn't support that 85th percentile was chosen because it will lead to compliance with water quality standards. The 85th percentile was chosen because on the cost curve, that's the happy place. And so they said, well, that's the cost-effective place to size our BMPs. And we say, okay, that's interesting, but it's not going to guarantee compliance with water quality standards. And what we say is, at the end of the day, you've got to demonstrate compliance with water quality standards through I mean, up front, the models should show that you're going to achieve it, and then at the end of the day, the sampling must show that you're going to achieve it.
And has there been any submittals that achieve that demonstration through this modeling process?
Not that I have seen, but I haven't looked at them at all.
Not that we have seen, but we also have, in our proposal, have asked that, a specific peer-reviewed modeling process take place, which is different than the reasonable assurance analysis that's required under the permit.
Steve? Another question, just to make sure I understand the proposal. So you're saying that the 5-year demonstration, are you saying that the 5-year demonstration should be that everything's met in 5 years? And that maybe I just misheard you.
That's true. That is true for water bodies without TMDLs. For TMDLs, it's specific to applicable waste load allocations within the 5-year term of the permit. So in some cases, that'll be interim limits. And just to also go to Member Dodek's point, those watershed management plans, or whatever they would be called, pollution prevention plans, would also include interim limits and interim deadlines that would need to be met. So that would also be a way to help determine compliance during the life of the permit and the life of the TSO.
And activity measures.
Exactly.
Actually, another follow-up question. If you could put up the first slide of where your proposal started, you listed some components, I think one of which was like a public input. Could you expand where in the process would you suggest those public input opportunity be provided? I mean, is it upon submittal, review, approval of the, I hate to use the word WIMPs and EWIMPs, but that is the acronym. Yeah. Would it be doing implementation? I mean, what is your thinking with respect to the appropriate timing for public input?
Well, I think you should always use EWIMPs instead of WIMPs, first of all. But
you started, Steve.
Because they're better. EWIMPs are better. Let's just be honest.
So they're BWIMPs. Sorry.
At the appropriate times. I mean, I think that would mean that upon submittal that, not only stakeholders themselves, but also their consultants would have or their experts would have the ability to review them. But I think the important part about our proposal is that we want to make sure that the standards for whatever the modeling is going to be are put in place, are robust enough for us to support the process. And that's what was really missing from the 2012 version of the permit, is the modeling that's required under the reasonable assurance analysis isn't rigorous enough, nor is it consistent enough for us to be able to fully and adequately evaluate how it's being implemented.
And it shouldn't leave you with the impression that the WIMPs and the EWIMPs don't have a public process. And if you remember my iterative process in my adaptive management slide, one of the benefits of the adaptive management process is there is more public process than there was under the 2001 approach. So we're not suggesting that there isn't public process. We're suggesting that any approach must include a robust public process.
And I will assume you'll expand upon your proposal in your written comment.
Absolutely.
Thank you. Look forward to reading that.
Thank you. We may have more questions later after we've heard from folks. All right, next we have, I don't know how to say this without going through all of it. You know who you are. Agoura Hills, Artesia, Beverly Hills, Commerce, Culver City, Downey, Hidden Hills, Inglewood, La Mirada, Manhattan Beach, Monrovia, Norwalk, Rancho Palos Verdes, Redondo Beach, San Marino, South El Monte, Torrance, Vernon, Westlake Village Group.
Thank you very much for preempting the first part of my introduction. You've saved me a lot of time. I just want to stress these are a variety of cities, some rich, some not so rich, covering at least 4 different watershed areas. Our presentation is going to start with Mayor Marianne Lutz, who is mayor of the city of Monrovia, and a former distinguished member of the LA Regional Water Board. We'll then turn it over to a consultant who will talk about the real teeth behind WIMPs and EWIMPs and the work that's being done now not just in the future, but now on those processes. And then I will revert to a few comments at the end, but not in formal rebuttal to my good friends at the NRDC.
We'll call you Citigroup A.
Good morning, Chair and board members. It is a pleasure to be before you today and to see so many faces that I know from the past and admire so much. Again, my name is Mary Ann Lutz. I'm the mayor of the City of Monrovia and past chair of the LA Regional Water Quality Control Board. The municipal parties and permittees, such as the City of Monrovia, have been developing their IRWIMP process for the past 2 years in our goal of retaining all the stormwater from the 85th percentile that you're fully aware of. In total, the City of Monrovia has committed more than $1.1 million in fiscal year 14-15 alone. We anticipate that that will double and triple every year for a substantial amount of time. But this is the money that we have committed this year. And we have no additional funding stream for this. Some of you are aware of this. Cities do not have a funding stream called stormwater that comes into the cities. So the money that we spend has to come from our general funds. The general fund money that is used for police and fire and public works and streets and roads and all of the things. So we do not have a new funding source to pay for this.
I'm sorry to interrupt you. Why? We did one in LA.
You did, and you may have done it prior to Prop 218 where you went to the citizens, where we were able to do that. Now we would have to go to a Prop 218 vote to do such a thing, which is a whole different animal. Okay. So in the County of Los Angeles, there are 3, maybe 4 cities that have current stormwater fees. The majority of cities do not, so we do not have a funding stream. We have, as I just said, spent numerous amounts of money and are continuing to spend money and anticipating spending money, and because of that, we are concerned with some of the things that are in your draft order. For example, the City of Monrovia is part of, as you may know, the Rio Hondo San Gabriel Valley Water Quality Group, our EWIMP, and it includes cities such as Arcadia, Azusa, Bradbury, Duarte, Sierra Madre, Monrovia, the County of Los Angeles, and the County Flood Channel. To date, we have spent more than $800,000 in consultant fees just to find out what we need to do to meet this permit. So in less than 2 years, we have spent that just to know where we go to create our plans. These plans are very important. The implementation of these plans will create BMPs and projects to meet the permit, and we anticipate that the cost of these projects will be multi-millions of dollars for all of us, these 8 cities, to spend money towards. So if this doesn't show a commitment, if it doesn't show that we are truly partners in this process to have grid water quality and to meet these permits, I don't know what does. Look at what we're doing. Look at the steps we're taking. As you heard from the regional board, cities are moving forward. They are working on this process, and we're doing it because A, we want water quality, and quite frankly, if it wasn't a financial issue, we wouldn't be even discussing a lot of this. If money was no object, we would just go out and do it. But unfortunately, we live in the real world, and money is an object. Furthermore, the cities like mine that have selected the EWIMP process have done so because we had a commitment from that permit that said that we would be in compliance while we go through this process. This is a commitment that we used to make a decision on which process we would use. If some of these things are changed, if the state board moves the goalposts, we have committed public money right out of our citizens' pockets for something that we will not be able to obtain, and we will not be in compliance. We have to look our citizens in the eye. This is a very serious financial situation for our cities. $1.1 million for my city in 1 year when our budget is about $35 million. and our unrestricted is more like 14 million, is serious money for us. So before I conclude, there are some things that I would like to, some compelling information I'd like to share with you, some about US EPA and some about the US Conference of Mayors in the discussion about affordability of permitting. As you all know, in 2012, the EPA created and developed their integrated municipal stormwater and wastewater planning approach framework. And that has been a very key element in the development of this permit. It's the integrated approach that you've been talking about all morning, that you talked with Santa Clarita about, that is key in helping everybody meet the goals. In the past, we had EPA Clean Water Act silos, where this was a permit, this is what you're supposed to do, and this is another one, and this is another one, but we all know it's one water, it's one drop. It's integrated, it connects together. This approach is to make that happen. Since that time, the US Conference of Mayors, the National League of Cities, and the National Association of Counties have been discussing and working with US EPA for the second step of this process, and that's an affordability matrix, financial capacity. And in November of this year, EPA submitted their final capacity assessment framework for Municipal Clean Water Act requirements. This is on their website. It was enacted in late November. And it quotes, "As programs are implemented to improve water quality and attain the Clean Water Act objectives, many state and local government partners find themselves facing difficult economic challenges with limited resources and financial capabilities." It's the tipping point that's happening all over this country, and US EPA with this document is recognizing that. The document also states that EPA will consider all clean water costs, all Clean Water Act costs. And that includes addressing the guidelines and examples that are relevant to consideration of the financial capability. It includes considering all of the costs for all of the different things that we do here in the water. It includes something that we just spoke about, Prop 218. It includes, quote, state and local restrictions or limitations on property tax and other revenue streams or debt limits. So it recognizes that we don't have a blank check to write, and that we need to look at all of these things when we are addressing this. They then took it to a point where they looked at how much is too much, and their main goal was a 2% median household income. So the US Conference of Mayors said, okay, how much are we spending already? Before our new stormwater permits, before we're working with our SSO systems, how much are we spending already? There's a report that is from the US Conference of Mayors, which has been concluded in the 1st of December. I have copies of it for you today, that show more than 30 cities answered a survey that we asked them, how much are your residents paying? Because all of the money comes from them, quite frankly. How much are they paying for your water, your stormwater, your wastewater, the whole thing? And what they found is that more than half the cities in the survey are already actually spending money in excess of that percentage. 10 of the cities are spending more than 4.5% of their actual income. And in, for example, Paramount, 39% of their residents are already spending more than that threshold for their water. The other 14 cities are spending more than 4.5%. It's 18% of their city or 20% of their city are spending more. So what that tells us is we've reached a tipping point. We need help. This IRWIMP process, this discussion, speaks directly to the fact that affordability, if it is not about affordability, if we didn't have the financial restraints, we could go out and make these things happen overnight, as the environmental groups have suggested, a 5-year plan. We need more time to plan these out, to find the fundings, and to make them affordable for our citizens. Thank you.
Thank you.
Thank you, Mayor Lutz. My name is John Hunter, Madam Chair, members of the board. I've worked on a number of the WIMPs and the E-WIMPs, and I'd like to just kind of briefly go over some of the finer points on that. First, what I would like to do is talk about the E-WIMP and the WIMP, the watershed approach as a whole. I just have a real brief slide here, and I just wanted to show you this, that all of the WIMP and E-WIMP groups have set up technical committees very similar to this. We just picked this one at random, but they have all been meeting mostly monthly or sometimes more than monthly, sometimes less often, but in general, it's been about a month. And I haven't seen this level of cooperation in years. The cities are coming together. They are making a bona fide effort to address the considerations that the MS4 permit is requiring. We did have, I'll be honest with you, when we had the technical committees first formed, we went back and forth sometimes for months debating the fine points of WIMPs and E-WIMPs. And ultimately, they do have the same goal of achieving the water quality standards. They're just on slightly different paths. There was a comment earlier about regional projects versus non-regional projects. I don't see that the point should be specifically that it mandate regional projects. In reality, though, the regional projects are the cheaper way to go. So if those are available, that's probably the way that the technical committees will aim for. But you shouldn't mandate that it be a regional project if other alternatives do exist. The debate that has gone on for months, some cities decided to go for the WIMPs and some for the E-WIMPs. That was their choice. They've all been submitted. The cost of these, and I do sit on a number of these groups, conservatively is $500,000 each. And you multiply that by 19 groups, that's approaching, if I do the math right, $10 million that has either already been spent or is going to be spent, and that's just to develop the plans and the path that is going to be outlined. So this is a considerable commitment that the permittees have made up to this point, and we are moving forward. The plans that have been submitted, the work plans, the E-WIMPs that are going to be submitted in June, are going to identify projects or potential projects that we are actually out in the field looking at and investigating to see whether they will work or not. I do want to talk about a couple of specific items. The reasonable assurance analysis should not be automatically triggered every 6 years. The RAAs, as we like to call them for short, are very expensive documents. They're very complex, very time-consuming to prepare. In some cases, it might be warranted, but it should not be automatic. The MS4 permit right now requires that the permittees and the watersheds do an adaptive management review of their programs every 2 years, which means we have to see how we're doing. We have to look at the monitoring results. We have to look at the projects that have gone in, their efficiencies. Are they working? And we have to do that every 2 years. And so every 2 years, we're reviewing this. And I think at that point, it would be prudent to say, we'll know within, let's say, 3 iterations of adaptive reviews that we will have a good handle on this. And we may need to do an RAA, we may not. One very important point is the monitoring plans that are coming out. The scope of the monitoring has tremendously expanded. In some cases, reaches have had no monitoring, no regular stormwater monitoring, and now they will be monitored. I'll just pick one, for example. Lower San Gabriel River has had minimal amount of monitoring in the river itself. We're going to be installing 4 to 5 new stations there, probably spending close to $1 million on this over the course of this upcoming year. So we've gone from essentially nothing to over $1 million. That's new data. That's data that's never been available to us. So at this point, to say, well, we're going to have to redo the RAA every 6 months, every 6 years, let us have a chance to take a look at that data and see how we're doing. And then we can decide. When I say we, it's certainly in conjunction with the regional board and what have you. And Norm DuPont, who follows me, will have some more information on that. There's been a lot.
Go ahead. Question.
On this point.
Stop the clock.
So you're saying 6 years is too soon.
So I just have to. I'm sorry. I just have to pay attention to how much time.
I'm paying attention to it.
Okay.
I'm watching it.
Okay.
Okay. Well, on this point, I think you hear about the reasonable assurance analysis is some old tools were put into a new context and watershed specific. This speaks to the need to go back to the assumptions of the model based on the monitoring information you described. Now you're saying the adaptive updates potentially can serve the same function, but maybe not, on a wholesale review of the reasonable assurance analysis. I think it's not my reading of the draft order isn't saying throw it all out and start over. It's and start from scratch. So is there sort of middle ground here? Because I think monitoring alone doesn't get to the heart of this, which are the assumptions of the model and how it's performing through the monitoring that you described in the new areas.
I think there definitely is a middle ground. Norm DuPont will have some suggested language that he'll bring up, but we do have in some areas a paucity of monitoring data that the models were based on, and we can review that and see how that fits in.
Yeah, and I think my reading of it, that would be my hope as a just solitary board member is that commitment to look at the monitoring. Is it showing what the RAA predicted? Because it's a large leap, as you point out, without a lot of monitoring to support the actual model development.
Correct.
And so I think that's what we're hoping for, is this commitment to look back and grade how we did in our predictions and then modify that tool as necessary.
Okay.
So I'm looking for suggestions, in terms of what does this process entail? So if it gets at the heart of that matter of confirming that the RAA assumptions, if they weren't reasonable, were modified and adjusted on a regular basis.
Yes, and I would say that if we do find that they're working, I would say that we probably wouldn't need an RAA, but that will be for several years in the future. Okay. All right, I'll continue, and I will be brief. There has been some discussions on the safe harbor during the WIMP and the EWIMP process. I'm just going to limit my comments to one very, very small portion of this. The way the order is written at the moment, we have basically, after investing these tens of millions and in some cases hundreds of millions of dollars in these projects, that while we're doing this, we have a safe harbor. If we find out that after all this effort, we're just not able to meet them, we just need a little more time, we would go to the regional board and say, can we have some more time? While we're making that request to the regional board, we're no longer protected by that safe harbor. And then once after the regional board says, yes, you can have more time, well, we're back to being protected. So what we'd like to do is basically say that in that interim, can we remain protected under the safe harbor as long as we can demonstrate that we are making reasonable progress. So with that, I'm going to turn it over to Mr. Norm DuPont to go into a few more details. Thank you.
There we go. Sorry. Okay, this might be for you or one of the other members of your team. Just trying to put it in perspective about cost. So you and Mayor Lutz talked about the significant investment that's gone in already. Do you have information about what it would cost in order to achieve the baseline commitments? Just to compare, the two different approaches.
Well, I have to be careful here because there are baseline commitments in the MS4 permit. I don't think that's what you're referring to. That's the day-to-day standards like enough street sweeping, enough catch basin cleanouts, and so on and so forth. Or are you talking about baseline water quality standard?
Water quality standards.
Okay.
Yeah.
Yes, I do, with the caveat that these numbers are all preliminary. The RAA, and I'll just use one river watershed, basically, and that is, I've just seen the figures come out. It's about $5 billion for the LA River.
And what does that include?
And that's adding the very preliminary cost estimates for the lower LA River, which is one watershed, the upper LA River watershed group 2, and the upper LA River watershed and the Rio Hondo portion. So there's 4 watersheds that are there. All the numbers are preliminary, but that's kind of what we're looking at to achieve our first cut at compliance. That does not include purchasing land. That's just construction.
Meaning, give me examples.
Of the numbers themselves?
Of the actions.
Oh, the actions.
I haven't looked at all the EWIMPs.
Oh,
or the WIMPs.
the actions would be basically, I can only talk about the WIMPs at this point because they're the only ones that are developed. But we are predicting we would need to capture about 800 acre feet of water. And I wish I had brought a slide with me that shows that. That's a lot of water. And so we would have to install detention basins, infiltration basins, things like that. And quite frankly, there's just not enough land to do infiltration and capture. So, I mean, regional projects, so we'll probably have to do a lot of green streets, which essentially means as we're doing street projects, we would have to essentially rip open the street and put in trenches there or put in wells in strategic locations and have essentially large gravel reservoirs under the streets. And you know, that can only really be done as these streets are being reconstructed. You just can't go out there, and how often does a street undergo a major construction? I mean,
generally not as often as you'd like. Speaking of someone who once ran a public works department.
Some neighborhoods think it happens too often.
Really?
But it's, as you can see, it's going to be a very long process. And if we're not in compliance while we're waiting for this street that's not going to be rebuilt for 10 years, I mean, we're faced with a choice: either reconstruct the street now or stay on schedule and fix it 20 years from now. And we can't fix all the streets, you know, within the next couple of years.
So I think I'm asking you to do is to paint a picture of the actual stuff. And you're sort of answering 2 questions. One is time, and the other is what do you get out of it? And if you're capturing that water, there's a water supply benefit too. So you're not just doing, I mean, the whole theory of this is to give more time to meet multiple local objectives with the same dollar.
That's right. And like in San Francisco, they do the water and the sewer. And so the water guys and the sewer guys got together, and the street guys, and now they have a plan to go through the city and county of San Francisco in a coordinated effort. So in the case of San Francisco, they do both sewer, you know, sanitary and storm sewer because they treat both.
Yeah.
So there are opportunities. I appreciate actually this discussion because it gets to the heart of the matter, which is it's an infrastructure renewal challenge for stormwater that mirrors sewer and water. And so I'm glad that folks are thinking along these lines. But I heard in your description, there's still opportunity to do a little bit more coordination with other pipes that are in the ground.
There's a lot of opportunity to do more coordination. But to answer your question, basically what we're doing right now is we're looking at schools and parks, and optimally we're looking at land along a river channel, but given the built-out nature of this of LA County, those opportunities just don't come along very often. But in the best world, we'll go out to a park. We'll see that it's on the downstream end of a sewer system, so we can rely on gravity. We'll go out to there, we'll do some drill tests, make sure that the water will percolate, and we will either excavate a huge portion there and turn it into essentially an infiltration basin, or we'll put some infiltration vaults, which are concrete structures that fill up with water, and then the top we'll cover with sod so that it can be a baseball or a soccer field while the water percolates down. If we start today, if we found a good candidate park today to do this, to be honest with you, it's a 4 or 5 year process to locate the funding, to go through the environmental, and then to get the instruction done. But that's basically, and that's basically where we're at with the WIMP right now, just to let you know. We've identified potential projects. We're starting to go out there and say, okay, which of these potential projects really will work?
Thank you.
Okay.
Helpful.
All right, thank you.
Mr. DePaul.
Chair Marcus and fellow members, this group of 19 largely supports the WIMP, EWIMP process. We believe time is needed for all of the reasons that Mr. Hunter just got through articulating. We believe that money is needed. We recognize Proposition 1, although by the time that gets rolled out and funds start to get distributed, we think that's even probably a year or so off. Maybe I'm pessimistic, but organizing the distribution of that much funds is a major task. And so we ask for, ultimately, approval of the basic concept. And I would just simply say, in terms of my colleagues who we respect highly from NRDC and Heal the Bay, the thought that this WIMP, EWIMP process is a sort of a toothless one, that it will just give us another further extension and we've already failed, I think underplays the Los Angeles Regional Board. I have dealt with them on both sides. I know Deb Smith, I know Mr. Unger, I've dealt with other members of their enforcement staff. These are tough people. If there is a problem with the WIMP or the EWIMP process, Renee Purdy's going to ferret it out. If there's something that comes in the 2-year monitoring results that, as the Italian said about his blind horse, no look-a-so good, I think the cities and municipalities in that watershed will hear directly from the Los Angeles Board. So at the end of the day, we ask that you place some faith on the Regional Board and its ability to implement vigorously, and as Amel said, transparently, the WIMP, EWIMP process. A couple of language changes that we're going to go through right now. First, Part 6C8B sub 1 says that we must submit a new RAA. This is on page 38 of the draft order. We would suggest that it be done as part of the report of waste discharge for the next permit term. Currently, that's going to be 5 years. The next permit may take a little longer, but we have to submit a report of waste discharge. That seems to us to be an appropriate time to consider whether the modeling work placed in the reasonable assurance document is working after at least 4 years of data, whether we submit something else and we put in a provision that says the executive officer may order such a submittal. So if it's not just up to the permittees under that proposed amendment number 1, all of these will be sent further. Amendment number 2, we suggest, and these are just to the draft order, they're not to the original permit. Part 6E2, sub E, sub 1, we think should allow for full compliance for the 85th percentile. If the 85th percentile storm capture doesn't work, we're going to have monitoring data 2 years in, 4 years in, a new permit possibly as early as 5 years out. We think that's plenty of time, but we think there needs to be a real carrot to give municipalities and permittees an incentive to do something that will achieve water quality and water resource in a really meaningful manner. The example of San Francisco might be one. There are others, probably much more numerous than my lawyer brain can conceive of. But we think that the 85th percentile is a goal. It was a goal in the board's own Caltrans order, and we think it's a goal that should remain here, but without the modification that was suggested in the draft order that says, well, if you don't immediately meet this by monitoring, then you've got to go on. Amendment number 3, the board suggested at pages 60 to 65 of the draft order that it was going to impose a new section 6B2 imposing liability on joint discharges absent certain limited defenses. Permittees don't like joint liability, but I'm going to move on. If there is to be a joint liability provision for violation of the receiving water limits, which is what this section is geared toward, we would ask that there be one more subpart put in. That is, currently there are 3 limited exceptions. You didn't discharge at all during that time period. Well, that's not going to float with most of us, even given today's rainstorm. You discharged, but you did not cause or contribute to the receiving water limit exceedance. Well, contribute to, conceivably, that could mean if you added 1 molecule of the particular prescribed compound, you're contributing to. So we think that there should be a 4th alternative, which is specifically to say that the joint permittees are in current compliance with the design or implementation of a WIMP or EWIMP. Otherwise, we have the possibility of liability and lawsuits, and that is simply not a good use of public funds. My colleague from the NRDC suggested that there had only been 2 lawsuits since the 2001 time period. Let me tell you a personal story about the second lawsuit, the NRDC versus County of Los Angeles. First of all, most cities could not afford that type of litigation. It involved 2 efforts to go to the Supreme Court, one of which was successful. It involved 2 trips, at least to the Ninth Circuit. It involved multiple hearings and extensive litigation before a very able district judge here in the central of California. Cities, lesser cities, the county can afford that. The county was wise. They have some reserves. But a lot of cities do not have reserves because of all the financial deprivations that have gone on since 2008. To expose them to that type of liability and litigation, even if it's a once-in-5-year event, is a horrifying potential. The other thing is all of the cities, or many of the cities that we represent, had to go back and forth with the County of LA about claims, potential cross-claims, tolling agreements, all of those things that spent money on my law firm, but not on stormwater clearance. If the policy is ultimately its enforcement and my law firm gets more money, I can be greedy, but I don't think that achieves the greater public good. I think the greater public good is to put the money and allow the cities some time to develop the realistic WIMP, EWIMP program under control of the states, of the Regional Water Board. The final provision is just the one that John Hunter mentioned. If we request an extension, we shall be deemed in compliance until that extension has either been granted or not granted. That was a point that John covered further, and I will not cover further. Unless there are questions, I think I've consumed my time.
Well, I have a question. You mentioned the LA Water Board staff's tough, right? And I did note that they said 7 out of 17 were deficient. Was one of yours one of the deficient ones?
One of the cities we regularly represent was in that category, sir.
Yeah. And so they're currently working on addressing those.
They are currently in discussions with Mr. Unger on others as to whether they have some options, but it's not an enviable position.
Right. Thank you very much. Next, we're with Group B, Huntington Park, Duarte, Signal Hill, Pomona, and Pico Rivera. And that's set for 20 minutes, and so we'll take our lunch break after that.
Good morning, Madam Chair, members of the board. Richard Montevideo on behalf of the cities that the chair just referenced. I'd like to start off by commending your staff. This draft order, as was mentioned at the outset, deals with 37 different petitions, dozens of issues, frankly, most of them very complex, and all of them very controversial. Although I don't agree with many of the legal propositions set forth in there, there can be no dispute that your staff has done an exceptional job in preparing that draft order, has looked at all the papers and the proceedings, and my hat's off to them for the job that they've done. So I'm not saying that I'm a member of the Michael Lawfer fan club.
It's not an essential prerequisite.
But maybe Amel's fan club, if that one is getting started. I would also say that the approach that's being taken, both in the permit and the draft order, is a solid approach. The cities that I represent agree with the WMP and EWMP process, the concept. They agree with the adaptive management process and the overlay of that process on the WMP process. They agree with the annual review process. They also even agree with the use of numbers for purposes of determining, measuring progress. So all those things we're in agreement with. We think this is a major step forward. The disagreement comes with the actual requirement to ultimately meet, either initially, depending on which route you go, or ultimately having to meet strict numeric limits. The NRDC presentation and their prior presentations have looked at municipalities as being, that they should be treated one and the same under the Clean Water Act as industrial dischargers. I think that the draft order recognizes the distinction. And it's a significant distinction. Congress has recognized the distinction. Where we believe that the draft order creates some concerns, legal concerns, is although it does a good job of looking at the Clean Water Act issues, we believe it fails when looking at compliance with the Port of Cologne Act issues. The Port of Cologne Act provides some very clear terms. It generally, when you look at Section 13,000, requires that the highest water quality, which is reasonable, be achieved. And a consideration, and this is a general policy requirement, that the total values involved, beneficial and detrimental, economic and social, tangible and intangible, be considered. So this is a general policy requirement. When you then move to the specific provision that deals with, that governs the issuance of WDRs, that is Section 13.263, and that section similarly references a need to consider the water quality objectives reasonably required for the purpose, and also the provisions of Water Code Section 13.241. So you have a particular provision under the Port of Cologne Act that says you have to consider, when you issue WDR, certain requirements, and you're supposed to provide some consideration to what is reasonable. What are the total values involved? Economics. When you actually get into Section 13.241, which I just mentioned is required pursuant to Section 13.263 to be considered when WDRs are being issued under the Port of Cologne Act, it provides more specificity. It requires, when establishing standards, the reasonable protection of beneficial uses. And it requires a consideration of a number of factors. Not to name them all, but the most important ones for today's proceedings, I would say, are the environmental characteristics of the water body have to be considered when you are developing WDRs and when the regional boards are developing WDRs. That, to me, is similar to the 13,000 requirement of considering intangibles and tangibles. In effect, they're saying consider what's going on the ground. Secondly, under 13.241, there's a requirement that when you are developing and you're trying to achieve water quality conditions, that those water quality conditions that you're attempting to achieve have to be reasonably be achieved. That is, you can't impose a requirement to achieve a condition that is not reasonably achievable under 13.241. Thirdly, there is a requirement under Section 13.241 to consider economics, and we've heard a lot about dollars. It's a reality, whether we like it or not. It is a reality, and the state legislature has determined that it's a requirement for purposes of issuing a set of WDRs, the state permit. The draft order seems to suggest that compliance with Section 13.241 is optional when it talks about that they have flexibility under the Port of Cologne Act to consider economics. But we would submit it's not an optional, a series of considerations that are optional. They are requirements under the law, and we know that because of the Burbank decision, which came out in 2005. In that case, the California Supreme Court was looking at the issue of whether in a wastewater discharge permit, which obviously was an NPDES permit, whether in that instance, the LA board was required to consider the economic considerations and the other factors under Section 13.241. And there was a big dispute over whether or not the way the statute read, you had to actually consider the 13.241 factors when WDRs are being issued. And here's what the court said. Section 13.263 directs the regional boards when issuing wastewater discharge permits to take into account various factors, including those set out in Section 13.241. Listed among the Section 13.241 factors is economic considerations. So the Supreme Court is saying you got to consider the 13.241 factors when you're issuing WDRs, assuming, of course, that federal law is not otherwise requiring the requirement. The court went on to say that the plain language of Section 13.263 and 13.241, that under that plain language, that a regional board consider the cost of compliance when setting effluent limitations in a wastewater discharge permit. That's what you're doing here. You are setting effluent limitations in a discharge permit for municipalities. And our concern is that you haven't taken a step back and carried the analysis in the draft order all the way through. There is a recognition in the draft order that municipalities are not industrial dischargers, that municipalities are not actually causing the discharge per se. They're not generating the wastewater. So there's a recognition of that. But there's not a recognition of the importance of also, and the requirement to comply with state law, including final numeric WQ bells on municipalities is an effluent limit that requires compliance with the Section 13.241 requirements. And the overall concept set forth in 13,000 and even in 13.263 of looking at, is this reasonably achievable, and looking at the economics of it. And similarly, including a reasonable assurance analysis requirement to require municipalities to implement WMPs and to propose WMPs and provide, as a part of that, a reasonable assurance analysis that these WMPs not may, not potentially, but will meet numbers. If the municipalities don't actually have a way to meet the numbers, how can they give you or give the LA board a plan that they will meet the numbers? A perfect example is the LA River bacteria TMDL, but you can pick basically any bacteria TMDL, usually wet weather, but even in some instances dry weather. How can you capture all this water and set up a system? And how can you develop a WMP that will provide a reasonable assurance that when it rains, like the rains we had last week, that we're not going to exceed the bacterial limits? You just can't do that. And the concern is that there needs to be a recognition in the actual permit. That recognition is required, we would submit under state law. The draft order, I think, recognizes that these numbers are not achievable, where it says that they may not be able to achieve water quality standards in the near term. And Mel even made a comment to that effect. But they also recognize that the WMP process is a significant undertaking. It's ambitious, yet achievable, but it doesn't say reasonably achievable. It's a rigorous process. even with respect to the stormwater retention approach. There's a recognition that even if you go that extra mile, which is a very expensive process that takes up land, et cetera, even if you go that extra mile, there's a recognition in this order that even then, the administrative record does not support a finding that the approach will necessarily lead to achievement of water quality standards in all cases. So what is the city to do? In effect, they are required to comply with a set of numbers. We're giving a pathway, which we wholeheartedly embrace. But ultimately, we all know that it's difficult for a municipality to meet hard and fast numbers. That's what this is all about. We're not the same as industrial dischargers. Congress recognized that we're not the same as industrial dischargers. We would ask that this permit and this order recognize that we're different and that it comply with state law. And our suggestion would be, look at what was done and what's being proposed for purposes of compliance with U.S. EPA established TMDLs. What the order says and what the permit says is you can comply with the EPA established TMDLs if you use a BMP-based set of WQ bills and wrap that into a set of WMPs. We would still apply the adaptive management process to that approach. But the difference is that we're being honest. We're recognizing that here's our plan. If you like it, great. Approve it and we'll move forward. We'll implement it. We'll comply with the adaptive management process. We'll give you our interim reports. And if we do all that, we should be in compliance. If you don't like it, tell us what's wrong. Tell us what more we can do. But we'll show you what we can do. We'll tell you what we think should be done. Work with us on getting that and on following that process and implementing these programs. But don't put us in a position where we're going to spend all these funds, do extraordinary efforts, significant undertakings, and then still be subject to lawsuits and having to deal with the cities having to expend funds on lawyers like myself and Mr. DuPont. So we would ask that you give consideration to the approach that you use that's suggested for the US EPA developed TMDLs. Use that same approach, only put it into an adaptive management process, and apply it to water quality standards and apply it to all developed TMDLs and any other numeric standards. Thank you. I'm going to turn things over to Mr. Farsing at this point.
Thank you.
Thank you, Chair Marcus and members of the board. I'll be brief because I know you're thinking of taquitos, and I'm thinking of a French dip sandwich at Felipe's. So
That's right. All good thoughts.
yeah, they're all good thoughts. I just wanted to talk a little bit about some of the practical implications of WMPs and the EWMPs, and I think the process could be improved. So let's kind of talk about that. When I really talk with city engineers about the WMPs and EWMPs, they're concerned about three issues. The first is the uncertainty that comes with an uncharted path. After designing and building the best of their ability, what happens if the stormwater BMP or device doesn't work as planned? Now, in the case of the bacteria TMDL, what happens if there's no practical solution? Imposing numeric limits on municipal stormwater discharges presents a series of issues. It's the difficulties in meeting them, the problems with exceeding them, and the costs and potential enforcement impacts. There's a second concern that's echoed, and you heard from Mayor Lutz, and that's really the uncertainty of how communities are going to afford the hundreds of millions of dollars of projects required under the WMPs and the EWMPs. This is a particularly difficult question for the gateway cities in southeast Los Angeles County because we're the epicenter of California's disadvantaged communities. One has to ask how California's disadvantaged communities will afford the new requirements when they struggle on a daily basis to provide basic services. I believe the lack of an economic protocol in a WMP and EWMP process presents a series of issues. What is reasonably achievable, environmentally sound, what's cost-effective projects based on sound science, and that would address the local water conditions. These are important considerations. I guess I'm going backwards or forwards? I'm not going anywhere. There we go. The other thing that I think a lot about is the uncertainty of watershed partnerships. Basically, it's very complicated, as you know, the urban environment. Will the public in my community accept spending local tax money to fund a project in another community? How will the costs be divided on regional projects? What happens if a disadvantaged community in a watershed can't afford the project? And what happens if the city can only afford to participate in regional BMPs and yet they're reporting water quality violations from their own outfalls? Will this really be a litigation between cities against cities? Will it be the county suing cities? How can we best prioritize these projects? And I think there's lack of answers within the tentative order. I started to think about lessons we could learn from California's affordable housing policy. And it's really a good example. The similarities between housing policies and the WMPs and EWMPs are striking. The state faces a difficult and complex problem in providing affordable housing. The state's economic well-being rests in part on creating decent, safe, and affordable housing for millions of Californians. Californians' affordable housing laws require numeric limits and time schedules. Many of the factors impacting California's housing affordability crisis are out of control of the cities. California's regulators and the legislature have resorted to punitive actions to, quote, encourage, unquote, housing production. The state has removed all financial support to local government to assist in providing affordable housing. Cities are caught in an endless loop of housing element revisions with no clear direction. Housing element comments from regulators routinely change and are viewed as conflicting and arbitrary. Litigation by housing advocates is now common. Public support for affordable housing erodes when housing decisions are forced on communities. This is really a critical time for the state board, local governments, and the environmental community to address similar structural uncertainties in the WMP and the EWMPs. So let's talk about how can we resolve some of this uncertainty. The tentative order calls for a rigorous and transparent watershed-based approach that emphasizes low-impact development, green infrastructure, multi-benefit projects, capture, infiltration, reuse of stormwater. Those are really great concepts, but designing and funding and constructing these type of projects is complicated. The urban environment's complicated. Geologic conditions, slope gradients, unstable slopes limit infiltration opportunities in Signal Hill and other hillside communities. High groundwater in cities such as Artesia, which is named after artesian wells, prevents infiltration. Small cities have limited staff, no scientists, no engineers. Let's take a look at the success in this, what I look at is the Los Angeles River Trash TMDL. The tentative order discusses a paradigm shift, how we're now moving to look at stormwater as a regional asset, and I think that's great. Now, I think in order to truly view stormwater as an asset and to provide local government with certainty necessary to make large public investments in capture and reuse, the order should be modified to extend a deemed compliant BMP pathway to local governments engaged in implementing the WMPs and EWMPs. Now, look at the Los Angeles River Trash TMDL. Instead of imposing strict numeric limits on the cities for stormwater discharges, it implemented an early planning process where the county and the city submitted designs for BMP trash controls. The BMP controls were tested and several were, quote, called deemed compliant devices, and they were approved by the regional board. Installation of the devices then became an equivalent standard as opposed to compliance with strict numeric limits. Now, the state board supported the installation of over 11,000 catch basin screens and inserts in the Gateway Cities area with a $10 million ERA grant. And I say it's resulted in substantial environmental benefits to the water quality in the Los Angeles River and to the beaches in Long Beach. This deemed compliant pathway has been a benefit to the cities by increasing compliance certainty. It's also been a benefit to the regional board by easing their compliance workload. And during that whole 10 years that we've been working on the trash TMDL, there's been no litigation over the implementation of the TMDL. The last thing I wanted to talk about is this financial uncertainty. The difficulty of funding stormwater programs has been underscored with a decision of the County Board of Supervisors to not schedule a Clean Water, Clean Beaches tax measure for an election in 2012, while the Community Clean Water Initiative in Contra Costa County failed the ballot in 2012. Now, the Los Angeles Division of the League of California Cities and California Contract Cities commissioned a study on the Clean Water, Clean Beaches measure, and the board, why did they table the tax measure? What were the obstacles? And you can find that report. It's called Stormwater Funding Options. And it outlines the difficulties that local governments face in securing new taxes and fees, but it also outlines the opportunities. And I think it's important to focus on opportunities. Providing a sustainable source of funding is complicated by state constitution and case law, and not all of our cities will be able to rely on a newly passed AB 2403. So finding sustainable funding is going to take time. It's going to require federal, state, and local partnerships. Watershed groups may need to apply for multiple rounds of grants. Until more permanent sources of funds are found, in most cases, as Mayor Letts indicated, we're going to have to rely on general funds, and we're hard-pressed to really find those. So we're suggesting that there be a standardized independent financial planning review process. The process would be based on existing California Water Code sections that Mr. Montevideo outlined. It would examine the existing costs to the watershed's households of funding water-related issues, and it would examine future costs and the financial capability of the watershed's communities to provide these local funding options. So really, we think relying on this adaptive management process, a deemed compliant BMP pathway, will answer the questions posed by local governments that are participating in watershed planning. And it's a very large commitment that we're making. I thank you for your time and consideration for my suggestions.
Thank you very much, and thank you also for painting a picture.
You know, these are important points. The governor's water action plan really zeroes in on this issue of uneven infrastructure funding in the water sector, you know, where water and sewer are able to more or less fund the needs of those infrastructure entities. And stormwater and flood control are funded approximately 1/10 of what the water and sewer enterprises are funded. And therefore, you have these serious affordability issues that you brought up in this last set of comments. And so just want to assure folks that you know, at the state level, we're very cognizant of this, and as in implementing the governor's water action plan, specifically action number 10, which is to identify financing opportunities for local government. You know, I'm personally working with the Local Government Commission, an outgrowth of the new groundwater legislation, but also recognizing these long-held, long-understood issues that have frustrated people for over a decade in terms of coming to terms with the need to basically renew the drainage infrastructure of California's great cities, and do so with the knowledge that, like LA region has brought, in terms of understanding what's possible to achieve multi-benefits, you know, of all those things we've been talking about. So one comment to the last panel, and you know, you can think of it how you want to formulate it in your comments. You know, I've heard this coming from LA region for the last 15 years, but now what's refreshing to me is this recognition of the multi-benefit economic benefit. You know, and so when we describe the costs of the infrastructure needs, let's also recognize that those investments we have to do anyway to prevent public safety problems. And then while doing it, we have a potential economic benefit in many areas in terms of water supply reliability that otherwise may not be there as much due to Sierra snowpack shrinkage and population increase and all those factors. So the economic analysis and what's reasonable, I think let's also take into account the investments we need to make for a local regional water supply that's sustainable. So that's all I have for there. But I would, in my comments, I just want to acknowledge this challenge, but frame it in an overall larger water infrastructure sustainability discussion and link it to the governor's water action plan and our commitment to implement that.
Thank you, Steve. Other comments, questions? Does anybody know or remember, wasn't there a bill that passed the legislature that Assemblyman Rendon did that makes it easier to get stormwater funding?
Yes, AB 2403, and that's where there's a linkage made between water supply and the stormwater infrastructure expenditure. So there has to still be a linkage. So there are conditions placed on it. So I would expect you have a good answer, but in getting the funding from the local ratepayers, you have to create that certain nexus between water supply and stormwater infrastructure.
That's correct. AB 2403, the cities in Los Angeles County worked with Heal the Bay to actually have that bill put forward, and it does move forward. But essentially what's happened with stormwater is we see it as an orphaned utility. It's not in the exemption section of Prop 218, so it's very difficult for cities and counties to move forward with tax measures because it's a 2/3 vote required of the general electorate. Whereas with traditional utilities, you have a notice and protest hearing,
Right.
and you have to get over 50% protest, which is often very difficult to do. So situations like San Francisco, where they have the combined sewer and stormwater facilities, that's a true utility where they can do protest hearings. You'd have to think about if they went to a tax format where they had a 2/3 vote required, would they be able to get their rate structure to support the billions of dollars that are in San Francisco? The Rendon bill is a good first step, but it doesn't apply to all cities. There's some cities in our area that have high groundwater. We can't show the nexus. We'll have to work really hard to show a nexus between capturing and infiltrating, and then also it coming through the domestic water system for some type of rate support. So that's one of the challenges we face. It's a great opportunity for a lot of communities and probably isn't used enough or will be used more.
Are you familiar with the California Association of Counties? They have an initiative underway to do legislation to rectify this inequity in Prop 218 funding.
There's been a lot of talk about and how exactly do you change Prop 218 because it requires a constitutional amendment. I think the Rendon bill was seen as a patch because we could change the Implementation Act. Prop 218 was so complicated, a year later the legislature adopted the Prop 218 Omnibus Implementation Act, and that's where they exempted the traditional utilities, refuse, sewer, and water. At that time, they weren't thinking about stormwater in 1999. Who was thinking about it needed funding? So amending Prop 218 is going to be difficult. It's going to have to require a lot of stakeholders involved in going through the constitutional amendments. So I think Rendon was kind of a patch to it to help cities and counties.
Thank you.
Okay.
I just wanted to flag that. That's helpful. All right, we'll now take a break. I suggest you get here. I want to give you at least 45 minutes, but we will in no event start later than 2, just as a warning. And we'll all be fed, happy, and ready to roll.